Lieutenant Colonel Scheller is going to stand tall in front of the man October 14th for his court-martial. Here's what to expect. There's been a lot of drama about what to expect in the Lieutenant Colonel Scheller saga, but we got a 30-year military judge that chimed in with what he expects to see and why. Let's take a look. For anybody who's been living under a rock and don't know, Scheller spoke out about Afghanistan and our withdrawal in the past 20 years of the battle plan by leadership. So Jeremiah Mahoney, who was a military judge for 30 years from 1970 to 2000, speaks out on this. He said typically a Marine would face 8 years imprisonment, forfeiture of all pay, dismissal from the service with a dishonorable discharge. That's probably what Mahoney's prosecuted over the years and what would be expected, quite frankly, if Scheller brought one of his young Marines up on charges. Mahoney goes on to say from the leaked documents from the Marine Corps that the Marines have reached an agreement where Scheller will stand trial before a special court-martial, which is the equivalent of a misdemeanor court. Now, Schiller's attorneys come out and said that the Lieutenant Colonel will plead guilty to some or all of the charges. We don't know yet. And that's where October 14th is going to get very interesting, and I'll tell you why. So Mahoney, remember, a 30-year judge in the military, said this guilty plea was likely part of a deal for having the matter dealt with by a misdemeanor tribunal. So I'm going to say this, go against the grain a little bit. I'm not sure if Scheller, he was on this other end. He was on the command. Would he allow one of his sergeants to get away with a misdemeanor on this matter? But that's what they've agreed to. Let's keep moving. Here's where the military courts get far different than civilian courts. This is the judge now, and expect he's going to come in and accept responsibility. In the government, the Marine Corps will present evidence in mitigation. So if Scheller can come in and agree he's guilty, and now he's actually got to prove his guilt and that he agrees to his guilt, and the government's going to come out and say, he's just accepting a deal, and he doesn't really feel sorry for it. This gets more interesting. For the guilty plea, the presiding attorney, U.S. Marine Corps Judge Glenn Hines, must accept Schiller's admissions. Seems pretty obvious what he's done, and he's guilty. That's what Mahoney said. He said Scheller will still have to face the judge and plead his guilt, and the judge must be satisfied that the Marine is indeed guilty. And you say, all of this is just standard fare, right? Not so fast. This is a public hearing. Here's what Mahoney says about it. Again, he's the 30-year military judge. What the judge will do is to conduct an inquiry with the accused personally on record, open court, asking him to judicially confess to the crimes, Mahoney said. The courts go much further than most civilian courts, ensuring, Mahoney says, typically the accused will back down because they really want to get the deal. But this is one of the cases where the issue will arise. He said the lawyers will tell them not to go back and forth with the judge of the nitty-gritty details because it's the interest of the accused to get the agreement. So if he agrees to it, like you see a lot of times litigation, but they don't really agree, they're just agreeing to the charges to get the case over with, now Scheller could have even more problems. Here's where we get to the insurrection language. From the October 8th story that I have a video on, the prosecution may argue not about the charges that Scheller was trying to fan the flames of insurrection. So bigger than even the charges. So Schiller's team, we get into the jockeying here, has smeared and criticized the leaked documents. Those documents from the video and the description, task and purpose put out, saying that Scheller was really more of an insurrectionist than he was just breaking some rules. That the military leaked the documents in an attempt to smear the client's reputation ahead of the October 14th trial. So this case is becoming more of a kangaroo court than I ever think I've seen the military hearing or read about. And this is Schiller's defense. He says when the public narrative isn't going towards the government's preferred narrative, they have a tendency to selectively leak documents to change the narrative. Well, we've seen that in civilian courts all the time. Almost that's the standard now. But in this trial, or in a military trial, you never read about this kind of stuff. Mahoney says if it was his command, he'd have the paperwork set and hand it to Scheller and give him his walking papers immediately and he'd become a civilian. In order to avoid any type of confinement and more drama about this. Here goes another curveball. Mahoney said part of the agreement may be for Scheller to never publicly repeat the previous statements that led to his charge in the first place. I don't see Scheller doing that, and that's going to be pretty interesting. And I suspect October 14th, this trial will be on ABC networks, fill in the blank. Mahoney did chime in on something that's been on everybody's mind. He questioned the legality of Scheller being thrown in the brig for an entire week without a pre-trial confinement hearing. Mahoney goes on, now this is the judge. This isn't CNN or me. The code is very clear on requirements for pre-trial confinement and confinement not to be used for punishment purposes, he said. Speculation why he was thrown in the brig, and we saw the congressional letter come out, was that he was thrown in the brig to prevent him from making more statements, which could arguably be an offense to do that. So now we get into interesting legal strategy or nuances. But Mahoney's saying throwing someone in the brig before the grand jury is pretty atypical, and I believe that's why he got released. Another interesting curveball, Mahoney took exception to the military attempting to hold Schiller's pretrial confinement hearing in secret. That was an October 5th hearing that kind of came and went in the news cycle. In that same day, Scheller was released from the brig. So now it went from a secret hearing to a public misdemeanor type hearing. And on that same day, October 14th, Scheller could get his walking papers. Here's an editorial. Do you think Scheller or any of his young Marines below him ever got this same treatment? I'm not against Lieutenant Colonel Scheller. I think what he said was admirable. I think the manner in which he did it was foolish. But I cannot imagine anybody but an officer getting this type of treatment for doing the same thing. We've got young guys in the brig for taking a selfie in an area deemed secret, and this officer could walk the same day for far worse in the eyes of the Uniform Code of Military Justice. This statement says a lot from the judge. The idea that they were going to have a closed pretrial confinement hearing in a non-classified case is mind-boggling. And it looks like the Marine Corps came to their senses about this one and let him out of the brig and decided to have an open hearing. Here's the fireworks. The October 14th trial will be public. Through a confidential source that told the Epoch Times, Schiller's camp is worried the venue won't be large enough to accommodate the numerous requests from the media, politicians, supporters, and the defendant's family. So now we're going to have another circus trial that we see almost in every high-profile case. So now we've got an officer brought up on 4 charges for court-martial, of which he would be, on his face, convicted of all of them. Here we've got a case typically that any other Marine would be in the brig for. I think all of us agree that what Scheller said on its face is not arguable. We did a terrible job in Afghanistan, our leadership, and they should be held accountable. He went a step too far when they said, shut up, keep your mouth shut about it. You still work for us, and kept talking, right? Put a gag order on him. He kept talking. Now, I think Lieutenant Colonel Schiller's points were all very valid. And I think if this happened to another junior military person, without this kind of support, they would be in the brig. And as Mahoney said, for no less than 8 years. Now we have an October 14th trial, which is going to be an absolute zoo. And Schiller's got a plan here. I don't fault Lieutenant Colonel, but he's very much about the process and about core values and leadership. And this is going to create a lot of dilemma for young Marines, young service members. We get somebody who clearly violates things that are part of the UCMJ, and in any other case, that military member would see time inside of a cell, no doubt, because they wouldn't have this public support. I'm sure Lieutenant Colonel Scheller, battalion commander, company commander, has burned guys for far less. So we've got some interesting moral dilemmas. Should it be that way? I'm not blaming Scheller, but the public support made a huge difference here. On October 14th, this will be one hell of a zoo, and probably once Scheller walks as civilian that day with his dishonorable discharge, we will hear some very interesting reporting.